Mute. Fine. Oh no, it's all right. Check.
All persons having any business before this court of appeals, held in court of state of New York, may not draw near. Give their attendance, and they will be heard. All please be seated.
Good afternoon, everyone. Judge Rivera will be appearing remotely, and the first appeal on this afternoon's calendar is appeal number 78, Anderson versus Anderson. Counsel?
May it please the court, Lyle Hoydu for Jack Anderson. All nuptial agreements are governed by DRL 236B3, and that's a statute that this Court of Appeals characterized as unambiguous in a prior case called Matisoff. In this case, 3 judges examined the agreement in dispute. They looked at the applicable statute, and they determined that it was valid because it complied with the statutory terms. In reaching that decision, the judges applied the plain meaning to the statute, as this court did in the Matisoff case.
So, counsel, if I can interrupt you, I'm on the screen. Hi. So, in Matisoff, we left open the question of whether or not the acknowledgement had to be contemporaneous with the signature. Why don't you address why the majority of the appellate division is wrong to take that position?
Yes, Your Honor. Well, first of all, a contemporaneous acknowledgement is not required by the statute, so it's not one of the terms that is specifically outlined. 2 is there's no real no definition as to what is meant by contemporaneous. The certificate itself, there's a part where it says, quote, the party acknowledged that he or she signed, end quote. And that would be past tense. So it presumes that the individuals are signing and then can later present that for
Yes, that's true, but that only means it doesn't have to be simultaneous. That doesn't mean it has to be contemporaneous. It strikes me those are 2 different things. But let me try this a different way. How is one party to the agreement holding off on the acknowledgement 7 years until just before filing for divorce really in line with the purposes and in recognition of the purpose of the acknowledgement requirement, the other formalities, and in recognition of what, again, the court has said over and over is, you know, that moment that you realize the consequences of signing that prenup agreement. Strikes me your client is making that assessment years later in a different context from the other party, but I think we have said in the past that the point is that these parties are assessing this at the time that they are deciding whether or not to enter the agreement, and that's when they sign, that's when those formalities ensure that the weightiness of these choices fall heavy on them and that they've thought them through.
Your Honor, we know that in general practice, these agreements are signed in counterparts. So whether that's in my own practice, I can say that they are either days apart, weeks apart, sometimes months, and I've even had them years apart. But it doesn't create a problem because it's a question of how the parties executed it, and there's no challenge during that pendency. In this case, the wife accepted the benefits of the agreement during the course of the marriage. She never raised any issues. There's no claims of fraud or duress here. And she never sought to revoke or rescind.
So let me ask you this over here, sorry. If Mr. Anderson had never signed the agreement, would it have been enforceable against him?
Not under the code, no.
So then, if we don't have some sort of contemporaneous requirement, that doesn't mean instantaneous, it might be in a month or 2, but something, you're essentially converting an agreement that the parties thought was going to bind them both into a one-way option for the non-signer.
And that was the rationale, Your Honor, that was raised by the Fourth Department.
And so what's wrong with that?
I think there's 2 problems with it. Number 1 is in this particular case, if the husband enforces the agreement, the wife gets exactly what she expected. If the husband opts not to enforce the agreement, then presumably that favors the wife and she gets something more, which would be a windfall.
Well, I don't understand that because not necessarily. I mean, what if all of a sudden he became bankrupt?
And you lead me into the second problem, Your Honor, that's exactly what it is it creates a subjective standard. So now the judge becomes outcome-oriented, so instead of just objectively calling balls and strikes, the judge has to consider how that call is going to affect a particular party. So if
Yeah, but it's not purely subjective. Of course, there have to be some boundaries. I get your point. I'm not going to disagree with you on that. But of course, it could have been resolved if your client had had it acknowledged within a reasonable period of time.
Well,
Again, it doesn't, I do think there is a difference between contemporaneous and simultaneous. And the court below didn't say it had to be simultaneous or that they both had to do it at before the same individual. So yes, of course, the circumstances might require that this is not done simultaneously.
the problem, Judge, is we're now going into an area of, as I indicated from my own practice, and I'm just in general practice, but I've got these agreements, as I said, days, weeks, months, and years apart where the parties signed them.
But is that a
no-
good thing, counsel? Here, sorry. That may happen, but is that a policy we want to encourage? I mean, it may be in your practice people sign these years apart, but why would we want that?
Well, my concern, though, is a rule that retroactively invalidates all these agreements that we think are valid.
I thought you had earlier said that in your experience, they were almost always signed simultaneously.
No, I must have misspoke.
Okay, I must have misheard you.
The vast majority are done in counterparts. The vast majority.
In counterparts contemporaneously?
In counterparts, meaning that the...
No, I understand, yeah, but within the week of each other?
Your Honor, it's sometimes the same day, it's sometimes within weeks, it's sometimes within months.
No,
and
I got that part. I was trying to ask about frequency.
I think that within, if the general rule is that they sign in counterparts, the majority of them are closer to the days and weeks as opposed to months and years. But we have agreements that are out there, and there's never been a statutory prohibition is the problem. And if we say that DRL 236B is broken, and we want to fix it.
But what if we say you need to do this within a reasonable amount of time? Would we really be changing the law because of all these people that signed it within an unreasonable amount of time?
Is that a 5-day rule? Is that a 5-week
But
rule?
that's an issue the courts deal with all the time. What's a reasonable amount of time?
Well, again, Your Honor, the problem is that it leads to potentially different calls by different courts if we're going to use a reasonableness standard. And then it creates an uncertainty in the law. It undermines the general policy, which is favoring these folks coming together and making their own agreement.
Yes, but that was my point before, that the purpose is indeed for them to come together and appreciate the consequences of the provisions of the antenuptial agreement, to decide it for themselves and sign this and comply with all the formalities. It strikes me that they're not coming to an agreement if, with your example, years later, or this case, 7 years later, the husband decides, I'm going to get to that courthouse first and get divorced, and let me get this thing acknowledged now that my lawyer has told me I got to do that to make sure this is effective. Do we want to have that kind of unilateral conduct that is not based on what the parties knew within the same amount of scope of time?
I
mean, what's wrong with just saying it has to be reaffirmed?
I understand. I see that my time is up.
If you would like to finish your thought, counsel, go ahead.
Judge, I get it. I go back to the dilemma the court talked about, though, in Matisoff, which is, are you guided by the plain meaning of the actual terms of the statute, or are you going to insert exceptions and requirements in order to achieve some other goals. And the court previously found the statute was unambiguous. The statute, I would argue, hasn't changed. And I would simply ask the court to find in this case, for the very same reasons, that it's not ambiguous. It's not required to be simultaneous or contemporaneous. It can be done in counterparts, and that takes over a period of time. And if we want to come up with a new rule, rather than invalidating all these existing agreements, something that is prospective, that is at least in the future, that the attorneys know how to advise their counsel.
Thank you, counsel. Counsel?
Thank you very much. Your honors are obviously very well familiar with the facts of this case. The one undisputed fact of this matter is that on September 11th, 2011, the date that respondent signed and had acknowledged the agreement, there was a time period from then until May 31st, 2018, where there was no enforceable agreement.
Counsel, if I can interrupt you, counsel, I'm on the screen.
Yep, sorry.
Hi. No, that's fine.
Hello?
Why isn't your adversary correct? Candy's not in a worse position. She agreed to this 7 years ago. It's exactly what she had agreed to.
I have an answer
Where's
to
the
that.
foul in it?
Respondent went through the entire marriage in the knowledge that there was not a valid agreement. And she could very well have made decisions during that time that she would not have made if there had been a valid agreement. She repeatedly, as her affidavit says, she repeatedly told her husband that there was no agreement. He'd never given her a signed agreement, that there was no agreement. And he threw in her face, there's a prenup, but there wasn't one, and she knew it because she hadn't gotten it. And she could very well have made decisions, as I say, for example, she could have made a decision not to save money on her own during the marriage when money was available to her, that because she knew that there was no agreement, and so she'd have access to all the funds of the joint marriage.
There's a fundamental issue, I think, that is it may be a mistake, that is underlying, I think, both of your views on this, which is that I think you're both assuming that Mrs. Anderson couldn't have made on her own a great deal of money, much more than her husband, or that somebody in her position, because we're not talking about these parties in particular, during the marriage. And that if, as your adversary said, the agreement would not have been enforceable against him if he didn't sign it, in that circumstance, she's not getting anything like the benefit of her bargain, right? She could have made a tremendous amount of money, and he could say, oh, you know what, the prenup is not enforceable because I'm not signing it today.
That's exactly right.
And that's a problem.
Yeah, that is a problem. That's a problem for her, because if she knows that it's not, if she's operating throughout the marriage as if it's not in effect, it's totally up to him.
My point is, even if she's not operating that way, even if she just hits the lottery on her own nickel, it's not a question of her reliance, I think, is it?
Well, I think to some extent that it is, and I think that that's what the Fourth Department indicated in their decision. But I think that if she had been, if he could decide whether to...
Excuse me, let me ask this.
Sure.
Isn't your argument, aren't you asking us to say, judges, number one, was there a contract in the absence of the signature and acknowledgement, right?
Yes.
That's the first thing. And if there wasn't a contract, then what's the standard that we apply to determine if there may have been a contract? And that would be a reasonableness standard, a reasonable person standard, as we would with any contract, right?
Right.
So he signs it late, so he waits 7 years to sign, or whatever the time period was. How long is too long? And is that reasonable? That's let me just finish.
I'm sorry.
That's the second part of it. Is that correct?
Well, I think that it's correct to a certain extent. Obviously, if a year goes by or a significant period of...
Let me answer this. If the reasonable standard is what you're asking us to apply, what you're really asking us to do is say, you want this to be a jury question. You want this to go to a trier of fact to determine whether or not there was a contract here when he signed it 7 years afterwards. Did that change the nature of the contract, or was there a contract to begin with?
What I'm saying is that that after a short period of time, her signature and acknowledgement have to be reaffirmed. If he's going to wait a year, 2 years, any significant period of time, then he's got to get her signature reaffirmed so that they're entering into the contract at the same time.
Thank you.
Thank you, counsel.
Thank you very much.
Counsel, I took the liberty of reserving 1 minute for rebuttal time for you, if you care to exercise.
Thank you, Your Honor. Counsel's aware of the concerns raised by the court, but again, these are like public policy concerns and rationales for why the existing rule should be perhaps amended. But the reality is that in private practice, these agreements are executed in counterparts on a regular basis. And now, without having a definitive rule, if we're going to have a rule that comes out that retroactively invalidates them, I think that creates an uncertainty in the law and a chaos. Because as I leave the courtroom today, I don't know what to advise clients in terms of how long between signatures or how long between a signature and an acknowledgement is valid or invalid. So that is all the more reason why such a issue should be resolved through the legislative process so that it gives notice to all the parties and all the litigants in New York State.
Thank you, sir. The next appeal on this afternoon's calendar is appeal number 79, matter of Cogel. Let's just wait 1 moment, counsel, till your colleagues clear out. Counsel, good afternoon.
Good afternoon, Your Honor. May it please the court, my name is Andrew Himmel from Himmel and Bernstein, and I represent the appellant. And I would like to reserve 3 minutes of rebuttal time.
You may have 3 minutes, sir.
Thank you, Your Honor. The key question, the core question before this court is whether this court should allow for judicial cures of materially defective acknowledgments or whether this consideration is best left for the legislature. The court in Goleta held that the defect in this case was substantial and material because the certificate failed to include all necessary statutory language in the certificate. And the RPL, the Real Property Law 306, states that a certificate must include this language. It uses the word must, and as this court has held, when a statute uses such mandatory terms, such as must or shall, the effect is peremptory. I mean, unless there is...
Counsel, if I can interrupt you, I'm on the screen. Thank
Yes,
you.
yes.
This case is very close to the hypothetical scenario presented in Goleta, which, given the way that hypothetical is presented, does suggest that the court thought, at least at that time, that perhaps it made sense when actually everything that is statutorily required is done, in fact, but is not properly articulated in the document.
Okay, Your Honor...
But the underlying facts cannot change, right? That is what happened here. Everyone agrees that the one thing that's missing is that proper acknowledgement, not that there wasn't an acknowledgement, but rather the documentation that there was a proper acknowledgement.
Your Honor, you're referring to the Goleta dicta, and what I would say to that is there's no hierarchy of the importance of the requirements for a valid acknowledgement. Part of the problem of the Goleta dicta was that it assumed that the first two requirements, the oral acknowledgement and the prohibition about a notary taking the acknowledgement unless he knows the signer or has evidence of such, it's not as if those two requirements are the important ones and the third one is not important. So there are three requirements, and Goleta...
Well, no, I'm not suggesting they're not important. I want to clarify sort of the context of my question.
Sure.
Because that would mean that we would jettison the requirement, and I think it's very clear that that's not what we're talking about here. The question is whether or not one could provide that requirement subsequently if the rest had been done in fact. Right, that's really the question.
Your Honor, I think that what happened...
I mean, the acknowledgement occurred, correct?
It did not. Well, it depends what you mean. The oral acknowledgement occurred.
Correct.
Step one. The
Yes.
notary knowing the signer step 2, that did take place. But the fact that the third requirement did not take place renders this defective. Which
Yes,
is
but although there's no hierarchy, all three are requisites. I'm not disagreeing with you about that. But the first two go to that heart of the party, right? The signer or the signers, knowing that they've made this choice, that they are foregoing perhaps some great benefits, or at least they understand the consequences of signing the antenuptial agreement. The last part, they might not even know that there's a problem, right? I mean, that's what Galetta says. Look, through no fault of their own, the parties are trying mightily to comply. They're doing what they need to do through no fault of their own now. The nuptial agreement would be held unenforceable when this is something that can easily be cured, because it's not about going back in time to do something that wasn't done. It's merely to properly document that it was done.
Well, Your
Right?
Honor,
That's the difference. Isn't that the difference? That you actually did do these things. It's about, as Galetta says, conforming the actual events with the documentation.
well, the conforming of the actual events was the language that Galetta used in Galetta dicta. But what happened here was, because the language was not placed into the certificate, I think the presumption in your question, Your Honor, is it really goes to the heart of this, is should cures be available in the first place? And it is appellant's position that there's no source of any authority for the judiciary to so act. There's no statutory.
Well, I think if I could just, I'm not going to disagree with that latter point. That's your argumentation. Certainly you may proceed with it. But I think really the question before us in this case is whether or not the evidence presented to address the gap was acceptable, given the statutory mandates. It's not whether or not, sort of writ large, the judiciary can go about the business of saying anything you want to do to cure your errors or mistakes or the deficiencies is okay. We're only talking about this one, which is everything happened as it should, as a matter of fact, but you don't have the proper documentation of one aspect of this that is outside the control of the signatories.
I don't believe that everything took place that is supposed to take place, Your Honor. That is our position. Even though it was out of their control, there's no statutory provision that says so long as it's out of their control, that can dilute the application of the third requirement. The third requirement is a material defect, which is exactly what Galetta held in any event. So the Galetta dicta, with respect to the Galetta panel, is in conflict with the holding of Galetta. This is a material defect. And in terms of whether there can be evidence to bridge the gap, that I think is just another way of saying, should cures be available in the first place? And it's appellant's position that there is no source of judicial authority to provide that cure. There's no statutory grant, there's no constitutional grant, and this does not fall into the doctrine of inherent judicial power, because that relates to a court's ability to exert power because it's a court, to control its own business. That doesn't apply here, where the legislature has so heavily occupied this area.
Counsel, let's assume for a moment that a cure is permissible. Are the affidavits that were submitted by the notaries here sufficient?
Yes, if a cure, if this court does what it has never done before, which is to allow for a cure under the acknowledgement method, then the Jacobson affidavit would be a cure. But I have to hasten to add that it would not function as a subscribing witness statement. It is completely defective as a subscribing witness statement. It only gains vitality if this court, as I said, creates a new path of validation, which currently simply does not exist.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Can you hear me?
We can hear you.
Good. I'm Susan Reed. I represent the executor of the estate, John Cogel. There are three areas that I would like to address. One is why the 1947 amendments, among other things, completely undermines Ms. Cogel's statutory interpretation argument that you just heard, that a waiver with a deficient certificate may never be validated or cured because the legislature did not use the word cure. The second area I would like to cover is why the rule, the bright line rule that she proposes, is uniquely terrible and unfair. And lastly, what the rule would be going forward. In referring to the 1947 amendments, you have to remember that the text of the law originally said that during the lifetime of the other, that the waiver had to be subscribed and duly acknowledged. Then the court, the surrogate in Erie County decided matter of Mall, which eventually made its way up here. It was affirmed without opinion. That was a case where there was absolutely no certificate. But he found that relating to the real property law, the surrogate subpoenaed a subscribing witness. There was a subscribing witness, and took the testimony from the subscribing witness that he'd been present, that he knew the Linda Mall, who executed the waiver, and then the judge issued the certificate. The Law Revision Commission thought that that rule should be codified in order to liberalize the acknowledgement requirement. And they did that by setting up two co-equal, and that's co-equal, not mutually exclusive, ways to validate a waiver. And that was the acknowledgement method and the subscribing witness method. It seems to me impossible to conceive that the legislature amended the law specifically to allow evidence from a subscribing witness to validate a waiver where there was no certificate of acknowledgement, but would not to validate a waiver where there was a certificate, an acknowledgement and a certificate, and the notary did everything he or she was supposed to do other than include all the proper language in the certificate. The surrogate below made a specific finding that the affidavits were sufficient because they were based on the notary's personal knowledge of the signers and their actual observation of the signing. Now, the surrogate below, and I understand from what my adversary just said that he thinks this should have happened, but the surrogate below did not consider it necessary to call the two subscribing witnesses for any kind of live testimony to this effect, to have them give their addresses, and then for him, the surrogate, to issue a certificate of acknowledgement. I didn't say that, he didn't say, my adversary didn't say at the time that that would be necessary, and there is certainly no doubt the surrogate would have done this if asked. Why is this bright line rule that's being proposed uniquely terrible? Well, I would say it's always unfair because what we're talking about here is a paperwork error. There's no fraud, there was no overweening of somebody's will. It would reward someone that got exactly what she freely bargained for, agreed to, at the expense of the beneficiaries, which is often, as it is in this case, the children of the testator's first family. And it's particularly unfair here where it was mutual. It doesn't have to be. Waivers can be unilateral. But in this case, it was mutual, which means that Ms. Cogel has gotten the full benefit of her bargain. When these two individuals married in 1984, she was 54, he was 60. There was no way of telling which one would outlive the other. She has basically received the full benefit of that bargain. And it would be like somebody who tries to rescind a contract when you can't restore what the situation was because, of course, Mr. Cogel has died. I think, too, that there's no offsetting benefit that you can find to this rule that they propose because today there's a form. In 1984, there was not. So it's not as though the court's going to make anything clearer by saying that by adopting the bright line rule that my adversary suggests. There still will probably be typographical errors. There will still be law office failure, which is likely what happened here. But for the most part, the bench and the bar absolutely understand what's required. As I said, there's a form. You can just get the form and fill in the form. I also would point out in terms of the unfairness that this is not an equitable distribution case. The surrogate cannot account or compensate in the award for the separate property that Ms. Cogel brought to the marriage. She can't account for her assets at the time of the death. All you would have here is 1/3 of the net minus statutory deductions. At least an equitable distribution if the prenup is thrown out, as if it's not effective in the matrimonial action, and that's what 236B3 says, that you can't use it in a matrimonial action if it's not properly acknowledged or proved.
Counselor?
Yes.
One of the things that strikes me is that in both the cases today, there's an argument that any change in the strictly prescribed procedure would create too much flexibility and essentially reduce it to a jury question and a question of fact that has to be submitted to a trier that would make it difficult for the practitioner to know how to operate. How do you respond to that?
Well, I think in this case, as I said in my brief, there are very few things that can go wrong. There are very few factual issues that can be presented. You know, you
But
either...
as you know, inevitably something will.
Well, sure. Inevitably, there'll be a problem, and inevitably, somebody will leave something out. But you have to do two things. You have to say, I either knew the person or took actions to make sure that the person who signed it was the person described. You have to take the acknowledgement, to have the declarant has to acknowledge.
So do you think it's the nature of what needs to be cured that distinguishes this case and doesn't make it totally arbitrary?
I'm sorry.
You think it is the nature of what needs to be cured and removes this case from something that would be a totally arbitrary cure?
I think it's the nature of what needs to be cured that makes what has to be done pretty obvious and doesn't really create any messy issues of fact that have to be either considered by the trial court or given to a jury.
Because that's the danger, I think, is those, as you put it, those messy issues of fact.
Yes, that was what Judge Kay said in Matisoff, was one of the problems she had in the Matisoff case, because you would get into an argument there about whether the two individuals during the course of the marriage had carried out their original intent. That's not the situation here.
Thank you.
I think the rule here should be at a minimum. The rule in the EPTL area actually, as it's been understood by surrogates through the years, is actually narrower than the Galetta rule, although I think the Galetta rule is a fine rule. But the rule, it seems to me, that in the EPTL area should be at a minimum that a spousal waiver with a defective certificate of acknowledgement is nonetheless valid and enforceable where the surrogate finds that the notary or other official who signed the certificate knew the signer and observed the signer execute the waiver. That's a very simple rule, and it's a very narrow rule.
Thank you.
If there are no more questions,
Thank you, counsel.
thank you.
Counsel, you have your rebuttal time.
Thank you, Your Honor. A few points. These are co-equal and distinct statutory provisions. The subscribing witness method and the acknowledgement method. We know this from Galetta because the husband in Galetta tried to cite Maul. That's the 1941 case that led to the 1947 codification. The husband tried to cite Maul as support. And this court, I believe it was in footnote 4 of Galetta, said no. Why? Because Maul is a subscribing witness case. It is not an acknowledgement case. So Galetta fully understood that these are separate and distinct approaches. The second point I want to raise is that my adversary has referred to this as a paperwork error, a law office failure. This is another way of saying this third requirement's really not all that important. The first two ones, that's what's really important. But the third one, setting forth the language, that's not so important. And if you blow it there, it's just a paperwork error. Not true. And we know that that's not true because Galetta said this is, in fact, a substantial error. The third point I want to make is that there was some discussion here about the benefit of the bargain. Now, you can line up the equities. Yes, there's an argument from respondent that she benefited, my client, from the bargain. The bargain is that William Cogel would take care of all of her expenses. My client can argue she was rushed into signing a prenuptial agreement 1 week before the marriage. This parade of equities can go on, but to link the question of whether a cure should be available to a weighing of the equities, that's a terrible idea, because it makes this a hopelessly fact-oriented inquiry, which it provides absolutely no consistency.
But counsel, I thought that, you correct me if I've misunderstood the record. I thought that she did admit that when she signed this, she thought it meant what's hers is hers and what's his is his.
The very next sentence, she said that in her deposition, the very next sentence in her deposition, which is page 200 of the record, is she said, but I had no idea that after 29 years of marriage, after Bill died, I would have no standing. So that's in the record. But I have to emphasize that her understanding this equitable weighing of factors, it applied to the second affirmative defense of unfairness. We lost that argument. That argument was struck. But all of those equitable factors that were so relevant to the first affirmative defense in this case are completely irrelevant to they're irrelevant to the first affirmative defense, which relates to the defect of the acknowledgement. And finally, the rule that counsel is proposing, it's very interesting. Where does the court derive its authority to fashion such a rule? It could be a good idea, but the issue here isn't whether it's a good idea to craft a rule. The issue is, where does this court get its authority to craft such a rule? It's interesting as long as there's a witness. So in other words, we're conflating the subscribing witness method with the acknowledgement method. Maybe that's a great idea. It's never been done before. Galetta recognized that these are two separate and distinct approaches. Even if it is a good idea, that's not enough for this court to act.
Yeah, but let me ask you this: isn't all the statute requiring that there be an acknowledgement? So if indeed that is documented, that actually occurs, but it's documented later, why wouldn't that be within the statutory mandates? Why is that so far afield from what the statute requires? Aren't you staying with the core requirement?
I can only answer the way Galetta answered. The defect is that there was no, in the certificate, it didn't contain the appropriate language. That's not only a defect, that's a material defect. It's hard.
Yeah, but it fails to articulate what actually occurred. It failed to properly articulate what actually occurred, right? That she acknowledges it before a person who indeed knows her and whom she knows.
That's correct, but that requirement...
It's not like later on someone is trying to acknowledge it. It's not like the prior case, right? No. You agree this is not like the prior case, that 7 years have elapsed and there was never an acknowledgement.
That's correct. This was relatively contemporaneous as far as the certificate is concerned. That certificate has to be attached. They're not really separate documents. It either has to be endorsed or attached. It rendered it defective because it didn't comply with that third requirement. And appellant's position is that you can't get around the importance of that third requirement. You can't say, well, that's so much easily more curable. Why don't we just allow for a cure? There has to be first an answer to the threshold question. Should cures be allowed in the first place? And appellant thinks not.
Thank you, counsel.
Thank you.
And at this time, the court will stand in a 10-minute recess in order to execute our cleaning protocols.
Rise.
Okay, good afternoon. This is appeal number 80 on the calendar. This is the people of the state of New York versus Sharon Lashley. Counsel?
Thank you, Your Honor. May it please the court, Michael Tarbutton for the people. Your Honor, could I reserve 2 minutes for rebuttal?
How many?
2 minutes, Your Honor.
Yes, you may, sir.
Thank you. Your Honor, this court should not expand the illegal sentence exception to the preservation requirement.
Counsel, I'm having difficulty hearing you.
Sure, I'll try to. This court should not expand the illegal sentence exception to the preservation requirement to include the defendant's claim. The defendant argues that the people's omission of tolling allegations from the predicate felony offender statement rendered her sentence as a predicate felony offender invalid. She also argues that she was not required to preserve this claim because her claim falls within this illegal sentence exception to the preservation rule. However, this court in People v. Nieves emphasized that that illegal sentence exception is narrow. It further explained that the illegal sentence exception does not include all sentencing claims. And in People v. Sams, this court set out a two-pronged test for determining whether a claim of sentencing error falls within this illegal sentence exception, and defendant's claim fails both prongs of that test. Under the first prong, Sams explained that to fall within the illegal sentence exception, the defendant's claim actually has to allege that the sentence is substantively illegal. It has to allege that the defendant is actually sentenced improperly, that she's not, in actual fact, a predicate felony offender. It's not good enough to simply allege that there was a defect in the proceedings used to adjudicate her a second felony offender. And that's what defendant here alleges.
Can I back you up a second? Just logically, isn't it the people's burden to establish second felony offender status for sentencing?
Yes, Your Honor.
You have the original record, so you have to establish that, and if you haven't done that...
If we haven't done that, then that means the procedures are inadequate to give the court. That's the defendant, if I'm characterizing it properly, that's the defendant's theory that the legality of the sentence for these purposes...
I'm just thinking of the burden here now.
Sure.
Just the burden. And if you haven't done it, wouldn't it be per se an illegal sentence, if you at least as to that portion of the sentence?
It's an error, Your Honor, but that per se error, but that doesn't excuse the defendant from the obligation to preserve that error. Because simply that something is an error doesn't mean the defendant doesn't have to preserve it. And Sams makes this distinction clear between sentences where there's an error in the proceedings were inadequate, from ones where, as a matter of fact, the defendant's claim was illegal. Sams itself is a claim of an actual illegal sentence case, where in Sams there was this sequentiality.
I think you're right about the defendant's burden to raise the issue. But wouldn't the appellate division have the ability to reach it in the interest of justice?
Yes, Your Honor, it would. And that's what we asked this court to do, is to remand, because it was an error to find that it was preserved as an issue of law, and they could consider it in the interest of justice.
Counsel, I'm sorry. We could do all of this, but it seems like that's a lot of work for a lot of other courts. Wouldn't a simpler rule just be like, why don't you file a right certificate in the beginning?
No, Your Honor, actually, for a couple of reasons. First, the preservation rule actually is, one of the purposes of it is to prevent unnecessary litigation and to make sure that errors are brought to the attention of the sentencing court and cured on the spot. Had defendant objected, we doubtless would have filed the proper towing allegations because they were in the rap sheet in the court file. We certainly could have done that before. We did that on remand, ultimately. Not part of this record, but we did ultimately file that. She was adjudicated a second predicate felony offender.
Well, let me stop you there then. Why isn't this moot?
Oh, it's not moot, Your Honors, because for one thing, she was given a different sentence, a lesser sentence. The initial sentence was 3.5 to 7 years. On remand, she was given 2 to 4. So we still have an interest in litigating that.
And is that because of a failure to show the predicate?
No, Your Honor. She was adjudicated a second felony offender at re-sentence, just like she was at the initial sentence. We filed the tolling allegations, which were there was no question she was a predicate. There were 6 years of tolling. And that was, again, evident.
So then you may have to explain to me why the former sentence would prevail over the new sentence.
Oh, because the appellate division's remand order, because it was based on a finding that there was an error as a matter of law, was erroneous. If this court vacates that, then that initial sentence is essentially resurrected, reinstated. The subsequent sentence is a nullity, and then this court would be back to the initial appeal, would have the decision to make of whether to reach the claim in interest of justice, or to not reach the claim, but to consider the defendant's excessive sentence claim.
Well, why was the second sentence lower if it was based on the same predicate?
Essentially, Your Honor, I think it's safe to say it was because of the COVID outbreak. The sentence was adjourned several times because of the concern about whether COVID was our position was that COVID was not a serious threat, given that it was not very prevalent in the defendant's correctional facility, but the defense counsel took a different position.
So your view would be if we were to reverse, then the initial sentence, assuming if we have to send it back to the appellate division, it gets through the appellate division again, would be reinstated.
Right.
And that other sentencing would be a nullity.
Yes, Your Honor.
Except that I think you said earlier that the appellate division could look at this in the interest of justice.
It could.
Even on the remittal.
It could, which is why, Your Honors, why you should vindicate the preservation rule in this case, because preservation always has the risk that a meritorious claim cannot be raised as an issue of law, but that's why the appellate division has interest of
And
justice
you also
jurisdiction.
think it could be raised on a 440.
Exactly, Your Honors, which distinguishes this case from the vast majority of unpreserved claims where the defendants don't have that option. They have to rely on the interest of justice jurisdiction,
But
which is
then
discretionary.
you're really not sort of meeting one of the fundamental purposes of the preservation requirement, which is some efficiency of some sort, right? I mean, if you're really saying, no, you shouldn't raise it on direct appeal, although you could reach an interest of justice, but if that doesn't happen, you can go by 440. You're multiplying the court proceedings.
Actually, Your Honor, 44020 is a better route to dispose of these claims anyway, because as happened here, on direct appeal, the appellate division can only recognize that there's a procedural error and has to remand. They can't actually address where record's not adequate to determine whether the sentence is actually legal or not. In a 44020, the defendant could have claimed her sentence was illegal if it had any merit. She could have raised that claim and had the sentence corrected in a matter of weeks, as opposed to waiting for over a year for the appellate division to remand it again and start over in a new proceeding to determine whether she was a predicate felony offender or not. So there's still advantages, procedural advantages, so far as expeditiously giving the defendant justice if there was an error, and conserving judicial resources. In a 44020 motion, of course, the parties could develop the record in the first instance. That's the reason a 44020 is there, so that you don't have to go through the cumbersome round of appeal and get back to the sentencing court, develop the record to begin with. So that's another reason why these cases, as a matter of policy, should be channeled into 44020. But as a matter of this court's precedent, this court's test set out in Sams requires that, because this is not a claim alleging a substantive error, it's only a procedural error, and it's not a claim where the legality of the sentence can be established on the appellate record. So for those reasons, it does fail the Sams test. And actually, I think the appellate division's remedy they gave is very telling, because the appellate division remanded for further proceedings in the court's words, including the filing by the people of a proper predicate felony statement. So the appellate division recognized that it's quite possible, as ultimately happened, the defendant would be a second felony offender, that her sentence was actually legal to begin with, and also implicitly recognized that it couldn't determine that on the present record. So that showed that this claim falls outside of this test in Sams and is not part of this very narrow illegal sentence exception. Your Honors, one more issue I wanted to address is that defendant argues that there was a notice problem, that she couldn't...
I'm sorry, counsel, I'm having trouble hearing you.
Sure, sorry. She argues that she couldn't have preserved her claim because she didn't have notice on what tolling allegations she had to dispute. But that simply misunderstands what she had to do to preserve the case. She simply had to point out to the court that the conviction that we allege was more than 10 years old and there are no tolling allegations.
Thank you, counsel.
Thank you, Your Honors.
Counsel?
Good afternoon, Allison Kale on behalf of defendant respondent Ms. Sharon Lashley. This court can dismiss here and should dismiss here as this issue is now moot. Ms. Lashley has been resentenced as a second felony offender.
Counsel, I'm sorry. In that proceeding, though, then it turned out that this was fine. The tolls actually were in place, right?
The prosecution met their burden and alleged the tolling, and that is what happened below with the resentencing, ultimately. But on this record before the court here, there were no such allegations made and no opportunity for anyone to challenge that. So first, this court should dismiss it as moot as to her. And this is not...
But counsel, on the mootness point, aren't the people aggrieved?
The people aren't aggrieved here because Ms. Lashley is a second felony offender. She was ultimately found to have the same...
But on the reversal, there was a sentence that was a reduced sentence from the original sentence, correct?
Correct. She did receive a lower sentence
Okay.
on the reversal.
Thank you.
This is not an expansion of this court's exception to the preservation requirement for illegal sentences. Ms. Lashley's sentence here, there were no allegations about tolling made at all. Under the penal law, this conviction was older than 10 years and could not be used to enhance her sentence.
Yes, but isn't your burden to show the illegality of the sentence from the face of the record, has to be readily discernible from the face of the record.
It is readily discernible
How
from,
so is that?
because this predicate was greater than 10 years old, and there is no allegations of any periods of incarceration anywhere in this record. It could have been anywhere else. It's not in the predicate statement. It's not anywhere else in this record either. And the penal law prohibits using a predicate that's over that 10 years when there is no incarceration period. And that's the face of the record that we have here. And it's not a mere procedural violation. It's a violation of the penal law. This predicate could not be used to enhance her sentence, as it was alleged by the prosecution below at the initial sentencing proceeding for Ms. Lashley. And
But to go to your adversary's point then, kind of the flip of what I asked him, why do we want this here now, and especially after there's been a resentencing where this felony actually did comply, you know, it was within the time with the toll, rather than having an obligation to say something then, which presumably what happened just recently would have happened all those years ago? Like, why would we want that rule?
this court has created the exception for illegal sentences for the preservation requirement because society's interest in not having illegal sentences stand is greater than requiring that initial objection.
But this isn't an illegal sentence. We know that it wasn't now. In fact, we really know it wasn't now because you had a resentencing. So why would we do that?
Because it was an illegal sentence when it was given to Ms. Lashley. In Sams and Santiago, there could have been other predicate offenses that applied that made them second felony or persistent felony offenders in the end. They could have gotten the same sentence in the end. In the People v. Fuller case, restitution could have been the same set below. But the problem is, if we countenance these illegal sentences, that's where the issue is.
Your adversary said earlier that your initial burden when you're raising the illegal sentence claim is to show that it's substantively illegal. And I'm sort of having a little trouble with the notion that something could be substantively illegal at one point of time and not at another. That doesn't sound substantive to me. That sounds semantic almost. So I'm sorry, can you just sort of help me understand how it was illegal then, but it's not illegal now?
It was illegal then because there were no allegations whatsoever about tolling. The prosecution has the burden to put that forth, and they didn't put it forth. That predicate cannot be used to enhance her sentence on that record.
But that doesn't make it any less legal or any more illegal, I guess.
I mean,
The truth is the truth. I mean, that's a pretty bold statement. The truth can be many things, but you know what I mean.
Yes, Your Honor. The problem is on the record before the court that was an illegal sentence, which was under their own theory substantively illegal as to Ms. Lashley. On that record, you could not enhance her sentence. There are tolling allegations that need to be made. That issue needs to be litigated. That needed to happen below, and it didn't happen here.
Could you distinguish People v. Pellegrino for us?
Sorry, Your Honor, could you refresh?
That's a memorandum decision from this court, which is similar to this, a defendant's argument that there was a failure to comply with CPL 421.
Yes.
And we ruled that it needed to be preserved.
So in those cases, Your Honor, and this applies to Proctor, Oliver as well, and Pellegrino, that's about how the manner of the predicate was determined, and this is about the predicate being used at all in this circumstance, and the predicate under the facts as alleged could not be used at all. It's not a manner determination about how the predicate happened.
I thought Pellegrino was about the failure to include the tolling periods in the predicate felony statement.
Your Honor, I don't believe that was the case specifically in terms of how the record, in terms of how that predicate was actually determined in the end. And that's why it's distinguishable from this case specifically. And to that extent, those cases, Sams and Santiago, put forth a new rule, which would be the one that applies here in this case. And I don't disagree with the prosecution that that's the rule, but the rule that they're putting forward is far too broad. It requires defendants to prove themselves that it's not, that the sentence can never apply to them, and that's not what this court has held, and that's not something that could be established on appeal. So to the extent that Pellegrino, Sams and Santiago put forward the rule that applies here. To answer that question, And the notice rule, our argument about notice, that is the real problem here. The prosecution has the burden to put forward these allegations, and they did not put those forth. And so that's why this illegal sentence exception should apply. And the 44020 is not a vehicle that will solve these problems. In 44020, there's no right to counsel, there's no right to appeal, and also you get to the same result. A plenary resentencing needs to happen here because tolling can actually implicate the sentence that someone gets. How soon someone got out of prison can apply to what kind of sentence the judge is going to get. And those concerns can happen at a plenary resentencing. So that's still going to need to happen, and it's going to be the same effect as litigating this on direct appeal. And there was actually no litigation at all about the tolling periods. The prosecutions conceded from the very beginning that they didn't allege this. It's always only been about preservation. And so the 44020 is not an end-all be-all answer to this issue and to it getting heard. It will result in illegal sentences being insulated from appellate review going forward as well. And to the extent that they're alleging any gamesmanship type arguments here, the prosecutor themselves.
Counsel, I'm sorry to interrupt you. I just have a question based on what you were saying. Would it be possible to get to this issue on direct appeal as an ineffective assistance counsel argument? Or is the record too thin to be able to do that either?
It is a possibility in this case as well. There would be arguments, as you pointed to, that the record doesn't show if there was a strategic reason to not object or not. But yes, and you could reach as ineffective assistance as well, in addition to interest of justice jurisdiction that the appellate division has. If this case were reversed and needs to be remanded to the appellate division for that determination, as well as her excessive sentence claim.
So let's talk about the remand to the appellate division. If this court agreed with you and it's remanded for purposes of the AD to invoke its interest of justice jurisdiction, I assume that what is happening there is that it would invoke its interest of justice jurisdiction to consider a claim that, again, if we hold it's unpreserved, that is unpreserved. But it sounds like you acknowledge that the appellate division will not be able to resolve that issue. It would still have to send it back. Is that correct? So they would end up doing exactly what they did here. Is that correct?
Except for the fact that there is a new judgment that exists as to Ms. Lashley, where the resentencing proceeding has already happened. So it would depend on what this court's order is in terms of what the appellate division considers. But yes, she would need to have a resentencing proceeding, or they could decide it themselves, which the second department did in People v. Tata. They ended up deciding the defendant's sentence themselves.
Okay, but there's where I'm confused. If the record doesn't establish the tolling, how would they do that?
It would need to go back to the
But
appellate.
that's my point. So again, it certainly the appellate division panel could have viewed whether they did this saying it's interest of justice or not. This would have been the same outcome anyway.
Yes. Yes, Your Honor.
Did you make an excessive sentence argument?
Yes, we did as well. That also needs to go
And
before the
they
appellate
didn't
division.
consider that,
No,
right?
it has not been reached yet.
So they could decline to reach this and then just consider the sentence excessive and impose the same one that was imposed before?
Yes, and Ms. Lashley has
You know, the
been,
one that was just imposed, I'm sorry.
yeah, at this point, Ms. Lashley has been out, released on parole for over a year and a half. The prosecution is seeking to send her back for less than 6 months in prison in the middle of a pandemic.
Thank you, counsel. Counsel, you heard respondents' argument as to why the illegality of the sentence is obvious on the face of the record? You heard.
Sure, I don't-
How do you respond to that?
Well, the error, the procedural error is evident on the face of the record. There are no tolling allegations, and there ought to be. But the illegality of the sentence is not evident on the face of the record, because the illegality of the sentence would require knowing whether there actually is tolling or not. And certainly the rap sheet, which is in the court file, suggests that there is, but that can't be used conclusively. So that suggests that you don't know. And again, the appellate division's remedy showed that. Your Honors, I want to address Judge Rivera's question about ineffective assistance, because I think that illustrates the reason for preservation should be vindicated in this case. If you had a meritorious claim, you might be able to tell on direct appeal whether counsel's ineffective. Here, counsel's definitely not ineffective because counsel negotiated a second felony offender sentence. Everyone knew she was a second felony offender, which is probably why this error happened, because litigators tend to focus on issues that are litigated, not on issues that are agreed to by all the parties. This is why cases, this kind of claim, preservation should be required, so that the defendant can't let an error go into the record that no one cared about because everyone knew it didn't actually implicate the actual legality of the claim, and then turn around on appeal and litigate it and get the windfall of, frankly, a futile remand, have a do-over that ended up having the same conclusion: the defendant was a second felony offender, which was the initial, of course, the initial.
I guess I don't see the benefit to the defendant. I mean, especially because the defendant could have raised this under 440. I don't see why anyone really would do this. I mean, I see it happen here, but I don't understand.
Why, the benefit of actually raising the claim to begin with?
Yeah, if it's meritless.
Right,
Right,
that's true,
well,
it was. Which is why preservation would discourage meritless futile claims.
But no, but I'm saying I think that the fact that it's meritless, I mean, all you get is what? You still, if you're incarcerated, you're still incarcerated. You get a remand, the people put their proof in, and you're where you were. What do you get out of that?
Right, nothing, which is why preservation would prevent those claims being raised as an issue of law.
Well, you'd raise them as 440s.
You could raise them as a 440, but frankly, Your Honors, the defendant is not going to have the motivation to raise a 440.
That's what my point is. I'm not sure why they have any different motivation on a direct appeal. It seems like you get nothing either way.
Right, but direct appeals tend to happen if there's any claim the record could be raised, even if it doesn't benefit the defendant. If I could.
Did you used to get
Sure.
something because of the sequencing, which you don't get anymore? Was that one of the reasons they used to want to do this? I mean, was that an incentive before? Because I know we changed some of the sequencing.
Right,
now,
right, where resentencing didn't actually change the sequencing.
Right.
And that wouldn't be, of course, in the defendant's case, because she did commit a crime subsequent to this. That's why her sentence was enhanced afterwards. But that wouldn't affect the case in that. Your Honors, if I could.
Counsel, if I can just ask you, I want to follow up on the question Judge Garcia asked of defense counsel. Could the appellate division avoid the remand for a resentencing by addressing this through excessive sentence?
It could, Your
If
Honor.
it's not clear what the sentence is, I'm just not sure. I'm asking.
Sure, it could. If this court finds that this claim requires preservation, the appellate division erred by reaching it as a matter of law, it would have to remand to the appellate division to determine whether it exercised interest of justice. If it did, that would require remand to the sentencing court for us to re-allege the tolling allegations all over again. If it didn't, it could say that's it, or it could decide that the sentence is excessive and reduce it. So that would be an option the appellate division would have.
Thank you,
Okay.
counsel.
Thank you, Your Honor.
All rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in the State of New York, may depart hence and appear here the next scheduled session of this court, at which time this court now stands adjourned, unless soon convened by the Chief Judge or the Senior Associate Judge present in the state.